started recording this, and I'm going to try to keep this brief. When I make these lengthy, then it seems to, people don't tend to watch them, so I'll try to keep it as brief as possible. So if there's questions, don't hesitate to ask. Before we get going, are there any questions? Marie, I see you've joined us. Thank you.
You're welcome.
Are there any questions that I can answer for anybody before we get going?
No.
Okay. Okay, great.
Not really.
Well, go ahead.
Yeah, there wasn't any questions from me.
Okay. All right. Hold on 1 minute. Sorry. For some reason, we were supposed to have a teacher's office hour tonight, and I thought it was at 8 o'clock, but it's actually at 7 o'clock. It was at 7 o'clock Mountain Time. Anyway, now they're calling me, so I'm not sure why that. Anyway, okay, so let's get going. So this week we're going to talk about Uniform Commercial Code, or the UCC, which you guys talked a lot about this in your study groups. There were some great study group questions in the review quiz. I think you guys will really enjoy. But anyway, so just a little bit about the UCC. It was really created because there was a desire to have some uniform contract law. You know, we just didn't, there are very specific rules around uniform commercial codes, not talking about just individual contract management, but uniform commercial codes. And so one of the things that we look at is when you're looking at contract management, you ask, does it fall under UCC, or does it fall under just normal contract law? And if it does, then you have to default to UCC. If it falls under like commercial contract, then you automatically go to the UCC. But it really emphasizes the bargains and practices that can protect consumers too, that are unconscionable or non-enforcement of bargains and practices. And so we're going to talk a little bit about that. So this is really about the sale of goods. And I think when I did this, Article 2 has already been rewritten, so I'm not going to go into a lot of detail about that. So goods are tangible physical property that are movable. And in one of the review quiz questions, they talk about sale of goods versus real property. So any thoughts about the differences? Can you give me an example of what the real property would be versus a real goods? Any thoughts? So a goods is going to be, you know, a goods that you can move, like a car, or you know, patio furniture. So those are sale of goods, or something that you would find in a retail store. Real property is not movable. So a home is real property, and even though you could potentially move it, it's still real property. A mobile home, unless it has been converted to real property, is a goods. So that's, you know, one of the examples of that one. So merchants, there was a question on the review quiz, and it was I didn't use the question because it was a little confusing. Merchants is very defined. They hold themselves to a particular knowledge or skill, but a merchant is also it's not just someone that has a skill, but a merchant is is typically, and what we're dealing with on a very regular basis is probably a store or an online store. We're buying from a merchant, but it also could be, like if you went to, a flea market or something, that person that's selling all those goods is a merchant. And they're required to operate in good faith. So they're, there's really a sense of responsibility that a merchant is held to, in the conduct, in how they conduct their transactions. And that's why we often see many vendors, when they're dealing with another vendor, let's say they're a manufacturer and they're buying parts, they're going to have a code of conduct that they hold all of their vendors to. And they rely on that, so it could be holding them to many things. Usually they're holding them to many things in that code of conduct. It can be the type of business practices, meaning, they're not dealing in child labor and things like that. We've heard a lot about that in the news, but also to the quality of the products that they use in their services and their products, which they in turn would sell to us, and which in turn would go out to the consumer market. So what is a sale? When we have a sale in a UCC contract, can anybody give me an example of what we would normally have in a regular contract if you and I contracted with one another to do something?
Exchange of good for money.
So the UCC does not require consideration. Did anybody kind of pick up on that as they went through the learning this week? The UCC does not require consideration. And in any other time that we've been talking about contracts, consideration is required, correct?
Yes.
Yeah. So just remember that in the UCC, there's a good, actually, again, there were some really good questions that came out of the review quiz. And there's one in there that talks about a promise, a written promise to give someone a product, and that's a valid UCC agreement. So sale takes place when the title to the goods transfers from seller to buyer for a price, and this is really critical as we're trying to determine. So if we've got maybe damaged merchandise, right? Shipment. So that really, that plays into that. So we have, like in shipment contracts, the title transfers when the seller delivers goods, and in destination contracts, the title transferred when the goods are delivered. So these are really important pieces to understand when, we're talking about UCC. Sale. When the goods are in possession of a third party, such as a warehouseman, the title and risk of loss transfer when documents of title are transferred. And all of these allocations of risk of loss can be altered in the contract. So that can be stipulated in the contract. Agreement under the UCC, this is compared with common law of contracts. The UCC places more emphasis on intent. So, and they will use that. So just remember that. We in former prior semesters, we've always had contracts created, and I'm going to give an extra credit opportunity to everybody here to write a contract. And I think you guys will have some fun with it. And we don't do it anymore in this class, which is really kind of, it was a great learning opportunity. If the parties intended to make a contract, then the UCC allows the following to be used: prior conduct, custom and usage in the industry, communications with the parties, reasonable terms. And if a term is left open, the UCC gap fillers are usable. So at a minimum, a quantity must be specified. Okay?
Hey, Cheryl.
Yeah.
When is this due, extra credit?
Well, I haven't posted it yet. So I won't post it probably till this weekend. So you'll have a couple weeks to put it together, and it's not a lot. I give you the specifics, and you just have to write the contract.
Okay.
Okay, so it is, you know, you contract with, it's actually a toy company that I use. So you are the retailer who's buying from the broker, the wholesaler. So it's between a wholesaler and a retailer. And I don't want to give it all away, but you have to remember that you're following UCC and some of the specifics of it. But it's a fun exercise. I wouldn't get too stressed about it. It's just really a nice opportunity for some extra credit. And it gives you an opportunity to put together a contract. And from the other side of it, really what it does is it teaches you how to read a contract and what you should be looking for. So when you actually create it, it puts you on the other side when you know, maybe down the road when you are in an agreement with someone. So it really transfers well to the other side of learning what should be in a contract. Okay, so termination of offer and acceptance under the UCC. A signed written offer by a merchant is irrevocable for the period stated in the offer, and then also up to 3 months. So it'll up to 3 months, but it usually defaults to the period stated in the offer. When we have an acceptance that has new terms, this is a counter offer. Okay, so whenever we start with something and then we add other language, it now becomes a counter offer. So the acceptance rule is the last shot. Whichever firm sends the last piece of paper controls the terms of the contract. So does that make sense?
Yes.
Yeah.
When I was reading in the book,
Go ahead.
when I was reading in the book, for the counter offer, I take it like if you want to sell me something and you said that you want to sell it for $10, and then I say, I give you an offer. I said, can you give it to me for $8? This is how I understand the counter offer. Am I right?
So the way that would work, so the first party, I say, okay, I'm offering this bike for sale for $10. And you counter by saying, I will give you $9 or $8 for the bike. So that becomes the counter offer.
Okay.
Okay, so that would be your counter.
Okay.
And then you can kind of read through these bullets. I'm not going to cover all of them because it's really just talking about what the counter offer looks like.
Okay.
Okay, can you guys see this okay? I should have asked that earlier.
It's a little bit, it's small.
Let me see if I can.
I can see it just fine.
There, how does that work? Does that work better for you?
Now. It's better.
Okay, great. Okay. So, and then acceptance, this puts the burden on the offerers to object to the additional terms. So like you come back and you say, I'll give you $8 for the bike. And I say, no. However, what we might do is say, I'll take $8 now and $2 down the road. So if additional terms in the acceptance conflict with the term in the offer, then both terms are thrown out. Now, the example of the bike is very generic. So be sure that you're looking at this, and you have to go down in order of time. So time makes a difference. A time stamp on things will make a difference here. Okay. And the last bullet's really important. Even if the writings do not agree, conduct of the parties can be used to determine the terms of the contract along with trade usage. So let's say that I say the bike is $10. You say there's $8, and I say no, and then I give you $8, and you say, okay, here's the bike. That's very generic in the sense of it, but gives you sort of an idea. The conduct of the parties can be used to determine the terms of the contract. We never talked about the additional $2. I just gave you the $8 and you accepted it and gave me the bike. So there could be an inference that there's another $2 owed, but the behavior of the parties, the actions of the parties will really start to determine it. In this situation, because you took the $8, that usually would infer that you've accepted the counter offer. But if I said no and took the $8 and gave you the bike, it could mean that, okay, I've taken the $8 as part of a down payment and you still owe me $2. So there's a lot, there can be some gray area, some of that. But even though the writings do not agree, the conduct can be used to determine the terms. So in this case, let's just say when I sold you the bike and I took the $8 and there was nothing else that was said about the $2, or you never got any email or never a bill for the final $2, the conduct could say that, okay, it was $8 and that's final. So modifications, terms not specified in the contract are open. And so when we get ready for for you to write that contract, you're going to see there's this list of criteria that you should really include in every contract. You don't very often see terms that are left open in contract, only because people have had so many problems with open terms, and it just leaves too many areas for conflict. Usually their price is always included. They can be modified without additional consideration as long as the changes are bargained for. So this goes back to where you wouldn't have to have consideration. And then we go to statute of frauds. A contract for the sale of goods in excess of $500 must be in writing, except for these bullet points. The goods are specifically manufactured for the buyer. The buyer admits there was a contract with respect to goods for which payment has been made in acceptance and which have been received and accepted. If the seller sends and signs a written confirmation of a prior oral agreement, it creates a binding contract unless the buyer objects within 10 days. Warranties, in this we go into express warranties are created by affirmative acts of the seller. And that's pretty specific. And it says just yes, an affirmation of fact or promise made by the seller which relates to the goods and becomes part of the basis of the bargain. And it can be created when the seller describes the goods and furnishes samples. Warranties create strict liability for the seller. And in general, warranties are based on factual statements rather than opinions about the future. However, a professional opinion can create a warranty.
So is that a lot like extended? Is that included extended warranties?
It could.
On products.
It could. Mm-hmm. It absolutely could. Mm-hmm. So implied warranties are part of every UCC contract unless disclaimed by the seller. Okay, because you're basically saying this is an implied warranty of merchantability. Goods are sold fit for the ordinary purpose for which such goods are used. That's why when you have damaged goods, those are usually returnable. So there's goods are fit for the ordinary purpose. Okay, they would pass without objection in the trade. It's adequately packaged, labeled, and contained, and conforms to the promises made in the label. This is where you will have manufacturers there. They have a burden of quality control. That's why you'll see them go to such lengths to ensure their packages are have a high standard of quality for packaging. They don't have parts in them, or things that shouldn't be inside that package that are not part of that package. So that's an implied warranty.
So is the implied warranties, is that like the warrant, like if you buy a product from the stores and they give you like 30 days to that, if it breaks or something's wrong with it, that you can return it with supposedly no hassle. Is that kind of like what you're talking about?
So this is, it can, yes. If we're it's not to be confused with like going to the clothing store and you buy a pair of jeans and it really doesn't fit well, so you return it. That's not necessarily an implied warranty. But if you buy the pair of jeans and they say this this material is good for life, and it and that's a very specific warranty. An implied warranty would probably be when you go and you purchase a lamp and you put the light bulb in, and the bulb works because you put it in another lamp and it works, but this lamp doesn't. The implied warranty is the lamp is going to work. And so that retailer would have, you could fall back on implied warranty for that. And that goes for a lot of, products out there. That's what the UCC is to protect a consumer. You've heard of a lemon law for vehicles. Okay, that's the implied warranty, is that this vehicle is going to work for me from a new car perspective. I'm going to get in, the brakes are going to work, I'm going to turn the key on and it's going to start. So that's the type of the buyer relies on the seller's judgment in selecting the goods for this vehicle, but we know it's going to work. That's kind of an implied warranty. But there are things. What's an example? I had one the other day. It'll come to me, which was a good example of an implied warranty. Just a minute. There was one I was gonna look up. Let me see if I got it filed. It's just a good example of implied warranties. I know what I was going to say. So sometimes you will see a product that's listed as is, and the seller is trying to avoid the implied warranty. So if you're going to buy a product and you think it's going to be something more than what it's not, but the seller says as is, they're avoiding the implied warranty.
Okay.
So does that make sense?
Yes.
It means that the representation of that product is not what the reasonable person would think. there's a warranty act out there that protects consumers with respect to these written warranties, and state laws usually govern implied warranties for nearly all purchases. So, you know, just about every consumer product purchase comes from an implied warranty of merchantability, which means it's guaranteed to work if used for its intended purpose. If you buy a blender that simply doesn't work, then you have the right to take it back for an exchange or whatever. So it's given its condition at the time of the sale. And the UCC, Article 2 of the UCC dictates the terms of a merchantable, and it has to meet certain criteria. So it's got to conform to the standards of the trade as applicable to the contract. It has to be fit for purposes that such goods are normally used, even if the buyer ordered them for something else. And they have to be uniform as to quality and quantity. The other piece of this is they have to be packed and labeled for the contract for sale, and they have to meet the specifications on the labeling. For instance, there was a company that I worked for, and they were indicted by the Department of Justice for, they sold tuna, and when you pack tuna, they have to meet a pressed weight. That's part of the constraints around the trade of that when you pack tuna, and it applies to a lot of others too, a lot of other products. But you have to meet a certain pressed weight, and they were selling below the pressed weight. And pressed weight means pressed weight of the actual product of the tuna. So you can't have other goods you can't have other products mixed in there. So the core tuna product had to meet a certain pressed weight, and they weren't. Limitations of liability. So when we have disclaimers of warranties, it can't fall below what the industry standard is or the state has put on that product. And disclaimers of warranties can't be in fine print. They must be conspicuous and boldface print, and must name the warranty disclaim. When you have a disclaimer as is for sale of good, it really creates a caveat. So it puts a whole lot of things into that bucket of as is. The limitations of the liability must also be conspicuous, and generally sellers will try to limit liability to replacement of the defective goods or the amount paid for the buyer. So this is just some more information on limits of liability, and I'll post this so you'll be able to go through it. So UCC Article 2 indicates that limitations of consequential damages for personal injuries for consumer goods is prima facie unconscionable. So on its face, it's unconscionable. So under the UCC, liability for breach of warranty is based on the seller status. So a manufacturer, distributor, and retailer could all be jointly and severably liable. Okay, they could all be brought in and responsible for the breach. Usually one will try to default the liability to the next. And the distributor and retailer may be able to escape liability if the manufacturer is solvent, meaning that the manufacturer was solely responsible for that breach. Oh, so here's a good point. Component sellers can be liable for breach of warranty if if their oops, I got a typo. If their components reach the consumer unchanged, such as a tire manufacturer. So here's where they could be held jointly liable. Purchasers, consumers, users, and even bystanders are entitled to sue in most states for breaches of warranty. UCC does not make use of the term material breach. This is not, and what I would encourage you to do is look up what that word, that definition is. Does anybody want to take a stab at it right now? What is a material breach? It's a substantial breach of contract, and it usually is excuses the harmed body from further performance. So it also gives them the right to sue for damages, and the UCC does not use the term material breach. Any deviation from goods called for in the contract violates the perfect tender rule, and thus it allows the buyer to treat deviation as a breach of contract. So in other words, typically they certainly wouldn't have to pay, and if there was some harm, then they could sue for some sort of remedy. But they're usually the seller is given a time to cure the performance. In other words, to make good. Okay. And so what that would mean is, like, if you've got some damaged product, then the seller is given time to cure the performance. So they can either replace it or offer a refund. Commercial impracticability. So akin to the common law doctrine of impossibility, but it's more liberal in keeping with commercial. I don't know why I've got that. There's another typo. So a party is justified in invoking this principle if an event occurs. And there was, I believe I posted a case on, what was it, the case with the school versus the milkman?
Yes.
Yeah, so that's impracticability. So go reference that. And so that the milkman milkman lost that case. He was saying that it was commercially impractical for him to be able to, he should have been able to get out of that contract because he was tied to a price that he felt was impractical for him to, for them to remain in that contract because of the amount of money that he was going to lose. Well, the way the court looked at it, well, then you shouldn't have locked yourself into it for, number one, so long and for such a large amount, because you could have reversed it and the schools could have, gone the other way too. So if you can't have, like, one's good for the goose and not for the gander, so to speak. I mean, somebody's going to come, one person's potentially could be at an advantage than the other, but it doesn't mean that we're going to allow you to get out of your contract just because you didn't bargain it correctly or calculate a price correctly.
Where did you post this case at? Because I've never heard of it.
I posted it in a video in community, the HOA, or on our Google Community and Office Hour.
Okay.
I'm pretty sure it's
I don't know if it was in an email, because I read it completely, but I didn't go to the Google Community to get it. It might be in your announcement. I think I read it in your announcement.
Yeah, I bet I put it there too.
Yes.
I did. I bet I did. Yeah.
Okay.
Okay. Contract damages. So, and I think I put this in my, there was also a contract video that I put out, and I included this in there. There's a very common equation that they use to identify contract damages that begin with the difference between the market price and the contract price times the contract quantity. So this is, I don't think, read through it when you get some time, but the highlight of this is to recover consequential damages. It must be shown that the breaching party had reason to know about those damages. And then repudiation of the contract. The UCC uses the term repudiation of the contract to avoid common law terms, anticipatory breach, which we know is a part of common law. The UCC grants the non-breaching parties, when a contract has been repudiated by the other side, more options to do what is commercially reasonable. So what do you understand what it means to repudiate a contract?
No, I don't.
It means refusal to perform. So there's an obligation owed to a party to perform, right? And so it's an act or declaration before the performance is due that the party will not perform. So that often happens. So let's just say you contracted to mow the lawn, you were paid, and you didn't. So you go sue, and the judge says, well, I'm going to order specific performance. So that means that you have to perform. And if not, you're going to have to pay something. So in UCC, the term repudiation the UCC uses the term repudiation versus anticipatory breach. So there's some things that the UCC has taken from common law contract, but they're using their own words, and repudiation is one of them. We normally don't see that in common law term. We'll see anticipatory breach or specific performance. Okay, let me see. Let me see if I can. Let me pull up just really quick. What did I do with that? Oh, it's the doctrine of impracticability. There it is. Yeah, this is it. So I'm just gonna hit the highlights of this. So, Maple Farms versus City School District. And so in this one, Maple Farms had signed a contract with the City School District for a certain price of raw milk, but by a certain time, the price of the milk could increase. And if the terms of the contract were fulfilled, Maple Farms would lose $7,300. The bottom line was the New York trial court ruled that inflation and fluctuating prices did not render performance impractical in this case, and granted summary judgment in favor of the school district. Meaning they just granted summary judgment. They just said, no, school, you're going to win. This is UCC's, a classic illustration of the UCC's commercial impracticability doctrine, as the courts still apply it today. So unless there's some unforeseen contingency that alters the essential nature of the performance, they won't let this they won't use this doctrine. So that's what we were talking about in that particular slide. Okay. All right. Any questions? I'm not going to go through it right now, but there is a little quiz that I'm going to put in there just so that you can run through a bunch of questions, and it'll include the answers, but it's just kind of a nice way to look at some of the UCC, just a review quiz, not like the review quiz that you see in iLearn, but it's just a PDF that I'm going to post up there, and it just gives some sample questions of UCC doctrine and various questions, and it's got the answers attached to it so that you can go through and just use it as a study guide. So,
And
yeah.
Is that going to be posted in the HOA too? The
Google community, I'll put it in the Google community, and usually I'll put it in the announcements page.
Okay.
Yeah.
Are you gonna post that PowerPoint too?
This one right here?
Yes.
Yes. Mm-hmm. Mm-hmm.
Okay.
Okay.
Yes.
All right. Any other questions?
No.
All right.
I don't have any more.
Well, thank you for joining me tonight. It's been nice. I appreciate it. Thank you very much. And I appreciate your flexibility with last week too. So I
Thank you so much for your help.
Oh, my pleasure. Thank you. Have a good evening.
Thank you. You too.
Thank you. And
Bye-bye.